now the secure units, and I think this is something that in the past no one really thought about quite as much. I mean, I'm sure there's many residents out there who are in a secure unit right now. The family authorised, but no one's gotten a legal authority from a guardian or a power of attorney to actually put them in there. And that's because it just makes, you know, sense for someone like Bernie to be put in the secure unit. It's a good environment for him. But there was a case in the UK, which is a signatory to the European Convention on Human Rights, and this really highlighted the issue about the use of a sort of restricted environment. So this HL, it was the case of Bournemouth. So HL was a 48-year-old man who was informally admitted to and detained at Bournemouth Hospital. He was described by the European Court of Human Rights as a person who has suffered from autism since birth. He's frequently agitated with a history of self-harming behaviour, and a person who lacks capacity to consent to or object to medical treatment. So the hospital didn't get a legal authority from the person who had that decision-making ability on behalf of HL to admit him, because the practice at that time was not to invoke any lawful legal powers when a person in his position was not resisting to those arrangements. So he was happy to go into the hospital, but he didn't have that capacity to make that decision. So his former carers took issue with it, and they arranged for proceedings to be taken on his behalf, and they claimed a writ of habeas corpus, so unlawful imprisonment, and also damages. The proceedings were unsuccessful in the UK. The House of Lords said that any actions taken by hospital staff to detain HL that might otherwise have constituted an invasion of his civil rights were justified on the basis of the common law doctrine of necessity. So that's really where, in an emergency situation, someone's about to self-harm or harm someone else, you can then detain them for a limited period to prevent that action from happening. And it's a sort of emergency type scenario. But his carers then took it to the European Court of Human Rights, which is above the House of Lords in the United Kingdom, and they said that it was a breach of his rights. In particular, relevant the Article 5 of the European Convention, which said that everyone has the right to liberty and security of person. No one should be deprived of that liberty, save in the following cases and in accordance with the procedure prescribed by law. So they said, so one of the exceptions was where someone doesn't have a sound mind, and they said here HL not of sound mind, but then they had to decide whether the detention was lawful. And the emphasis of the convention is on maintaining people's liberty. And so even though there was provision in the UK that enables people to be detained, they said that there wasn't sufficient safeguards in those cases for that to actually be illegal, to be lawful. So they determined his detention was unlawful because there was insufficient procedural safeguards to guard against arbitrary detention. So in other words, the UK had to change their law because of that. The Victorian Law Reform Commission has pointed out that because we have a Charter of Rights in Victoria, the same scenario could actually arise here. And there's been a case even in New South Wales where the sister of a guy who'd had a long-term disability, she arranged for a fence around his house that he couldn't get out of. He was living in I think a rural property, and she wanted to ensure he could use the garden, but she actually went and got authority from the guardianship tribunal to make that decision, because and they said that it was good she did, because otherwise it would have been unlawful. And that's clearly someone who's acting in his interests, giving him freedom but just preventing him from wandering out and injuring himself. So as you can see, there are analogies in aged care. So even if someone's not necessarily resisting being in the unit, then it could be that you're actually unlawfully detaining them if you don't have that consent. Now, we're not. The legal answer is to this scenario is you need to go to VCAT and get consent, or get consent from a guardian. a lot of people don't have guardians, but they've appointed themselves. I don't know how often you come across enduring guardians. Is that powers of attorney are a bit more common, guardians not so much. I think we might see that change with the changes to powers of attorney legislation. But the point is, if someone hasn't already appointed someone and given them that specific authority to detain me, then if I am detained, then there may not be on that person's decision, then that may not be lawful. I don't think VCAT's going to want every aged care provider rushing down to get an authority for every single person. So we're not saying you need to change your practices for every person, but I think where there is a difficult family or there's conflict within the family about that person's care needs, it is something that perhaps you should think of. As I said, you've only got limited resources. So does VCAT, and trust me, they're already struggling to keep up, and so does the OPA. The Office of the Public Advocate also have quite limited resources, and I think they're quite under-resourced at the moment. So in most cases, the informal arrangements that we have currently will be fine. It's just those categories where you think, oh, something could happen here. Say a family like Mr. HL's in the UK there. So just wanted to raise that.